Can a sponsored worker be made redundant? The answer is quite simple, yes. As long as you follow the normal redundancy process and ensure you don't differentiate in your treatment of sponsored workers and settled workers, there's no reason not to make them part of a redundancy scheme. Any employee who's worked for you for 2 years, regardless of their immigration status, is entitled to statutory redundancy pay. The amount of that redundancy payment has no regard to their visa status whatsoever. If it depends on their pay, their age, their length of service, but it certainly doesn't make any difference as to the status of their visa, as long as they're obviously legally in the country and on a proper visa. I'm not going to go into the redundancy process. It's a huge undertaking, and now is not the time. Suffice it to say that you just need to be aware that any pool of potential redundancy candidates and the criteria you use needs to be carefully thought out so that it's not discriminatory. When you have a workforce made up of both sponsored workers and settled workers, you just need to be a little bit more careful perhaps about how each group of people may think and feel about the process that they're going through, because the same situation could make potentially both groups of workers feel discriminated against for different reasons. So you just have to navigate it very carefully. And we would say seek advice early on in the process from an HR professional, from a lawyer, or whoever you want to assist through the process so that you don't fall into any of the pitfalls. For example, settled workers may feel that they've been unfairly selected for redundancy because the business owners know that a sponsored worker would find it harder to secure alternative employment in the UK, because obviously they're restricted to securing employment within a sponsor license holder, and taking into account all those consequences. So they might feel that the sponsored workers are at an advantage because effectively the employer feels worse for the sponsored workers than the settled workers in terms of finding new jobs. At the same time, and with the same facts, potentially the sponsored workers could feel that they've not been offered available alternative jobs because of the need for the sponsor worker to apply for a change in their visa or a new visa on the basis of the differentiation of the job. Obviously, as long as you're selecting the pool of candidates not based on race, nationality, or visa status, you just need to be very focused on the fair selection criteria to try and avoid some of these grievances. Any employer making redundancies must make genuine efforts to see if there is a suitable alternative employment for those redundant employees, either within the business or any associated company. If there is suitable alternative employment, then it should be offered during that redundancy consultation process. A sponsored worker can only accept an alternative job role with the same employer under the terms of their visa if the job remains within the same SOC code as their original code. Otherwise, as I said before, you would need to, if the role will take the sponsored worker out of their current SOC code, you'd need a new visa application. That can tie in, if you're going through the process now, obviously that can tie in with the help that's available in terms of they could potentially start immediately the job until the end of September while that application is in train. But if you end up looking at redundancies later down in the year, it just depending on what the Home Office advice ends up being, that you may have to start from scratch with those visas again. So if you have alternative job roles to offer to a pool of candidates for redundancy, it's important that you just need to take advice on the process that any sponsored work will need to undergo to take on the new job role if offered. That's really with regard to the application for the visa. Also, very fundamentally, that care is taken to ensure that the selection process for the redundancy pool and the offer of alternate jobs is not discriminatory. For example, if you only place settled workers in the pool for redundancy selection and the offer of alternative jobs, because you don't want the hassle of having to reapply for visas for a sponsored worker to take on a new job role, that could be quite clearly leaving you open to claims for discrimination. Now, if you don't follow the redundancy process carefully, and if workers do feel marginalised or not included in the decision making, or for whatever reason, the main claims that you could open the company up to are claims for unfair dismissal and for discrimination. Now, claims for unfair dismissal can only be brought by a worker who's worked for you for 2 years, but that doesn't matter whether they're sponsored or settled. On the other hand, discrimination claims have no qualifying period at all, whether they're settled or sponsored. If they believe they've been selected for redundancy on discriminatory grounds or based on unfair selection criteria. When there are potential disagreements over the selection of the redundancy pool, we recommend taking early legal advice and to consult with your workers on the membership of those redundancy pool of candidates, so they are involved in the process from the beginning. Interestingly, a dismissal of an employee will be deemed automatically unfair if the employee has been selected for redundancy for an inadmissible reason. So it's just automatic. If the reason they've been selected is because they're a sponsored worker or because of the nationality or whatever reason, then that's an automatic discrimination situation right there. You can use length of service within the business as a criteria. For example, last in, first out. It's a fairly common scenario. Just be very, very careful that you avoid any allegations of indirect discrimination in that case. For example, if the last in, first out policy means only sponsored workers are at risk because your business only recently started sponsoring visa holders. So it's not just that you're not being discriminatory, but you need to be seen not to be discriminatory and not leave anything open for argument there, because you could well end up in a tribunal, and you do not want to end up in a tribunal. It can be expensive.